Tariffs case summary. Welcome to Law and Society. Please subscribe. Today, I'm going to read you excerpts from the tariffs case that the Supreme Court just ruled, saying that Donald Trump does not have the power to tariff nations on the basis of IEPA, which is the International Emergency Economic Powers Act. I'm not really going to explain much because I think the words of the court majority are self-explanatory, and the excerpts that I've come out with are fairly explanatory. The whole opinion is about 170 pages, but the actual majority opinion is only about 30 pages. Not even that, because there's the syllabus. Then there are large portions of Justice Gorsuch and Justice Barrett, and also the Democratic justices, or the left-leaning justices, Sotomayor, Kagan, and Jackson. They all wrote separately on the points of why they were for or against. And so I won't go into those other explanatory dictum, concurrences, and dissents, simply because what really matters is the majority's statutory interpretation of IEPA and the fact that it does not confer on presidents the power to tariff. So with that said, that's just the brief of it. I'll read you now the summary. We decide whether the International Emergency Economic Powers Act authorizes the president to impose tariffs. When acting under IEPA, the president must identify an unusual and extraordinary threat to American national security, foreign policy, or the economy originating primarily outside the United States. And he must declare a national emergency under the National Emergencies Act. Based on two words separated by 16 others in Section 1702 of IEPA, regulate and importation, the president asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words cannot bear such weight. The Congress shall have power to lay and collect taxes, duties, imposts, and excises. And this is what the court calls the one great power upon which the whole national fabric is based. So raising money to be able to do anything is a massive power, and Congress wields that power. The power to impose tariffs is clearly a branch of the taxing power. A tariff, after all, is a tax levied on imported goods and services. Recognizing the taxing power's unique importance and having just fought a revolution motivated in large part by taxation without representation, the framers gave Congress alone access to the pockets of the people. And in this reference, the Supreme Court goes straight to the Declaration of Independence and how that declaration itself says that, taxation without representation is one of the grievances that are mentioned in the Declaration of Independence. They required all bills for raising revenue to originate in the House of Representatives. They did not vest any part of the taxing power in the executive branch. President enjoys no inherent authority to impose tariffs during peacetime. And the United States, after all, is not at war with every nation in the world. The government instead relies exclusively on IEPA. It reads the words regulate and importation to effect a sweeping delegation of Congress's power to set tariff policy, authorizing the president to impose tariffs of unlimited amount and duration on any product from any country. We have long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. Both separation of powers principles and a practical understanding of legislative intent suggested Congress would not have delegated highly consequential power through ambiguous language. These considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. If Congress were to relinquish that weapon to another branch, a reasonable interpreter would expect it to do so clearly. What common sense suggests, congressional practice confirms. When Congress has delegated its tariff powers, it has done so in explicit terms and subject to strict limits. Congress has consistently used words like duty in statutes delegating authority to impose tariffs. And, it has capped the amount of the duration of the tariffs. It has conditioned exercise of tariff power on demanding procedural prerequisites. Against this backdrop of clear and limited delegations, the government reads IEEPA to give President power to unilaterally impose unbounded tariffs. On this reading, moreover, the President is unconstrained by the significant procedural limitations in other tariff statutes and free to issue a dizzying array of modifications at will. All it takes to unlock that extraordinary power is a presidential declaration of emergency, which the government asserts is unreviewable. And the only way of restraining the exercise of that power is a veto-proof majority in Congress. That view, if credited, would represent a transformative expansion of the president's authority over tariff policy, and indeed, as demonstrated by the exercise of that authority in this case, over the broader economy as well. It would replace the long-standing executive-legislative collaboration over trade policy with unchecked presidential policy making. Congress seldom effects such sea changes through vague language. It is also telling that in IEEPA's half-century of existence, no president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. The lack of historical precedent of the IEEPA tariffs, coupled with the breadth of the authority that the president now claims, is a telling indication that the tariffs extend beyond the president's legitimate reach. The economic and political significance of the authority the president has asserted likewise provides a reason to hesitate before concluding that Congress meant to confer such authority. The president's assertion here of broad statutory power over the national economy is extravagant by any measure. Economic and political consequences of the IEEPA tariffs are astonishing. A reasonable interpreter would not expect Congress to pawn such a big-time policy call off to another branch. Emergency powers, after all, tend to kindle emergencies. Where Congress has a reason to be worried about its powers slipping from its fingers, we in turn have every reason to expect Congress to use clear language to effectuate unbounded delegations, particularly of its one great power, being the power of taxation. The framers gave the power to Congress alone, notwithstanding the obvious foreign affairs implication of tariffs. We would not expect Congress to relinquish its tariff power through vague language or without careful limits. The president must point to clear congressional authorization to justify his extraordinary assertion of power to impose tariffs, and he cannot. To begin, IEEPA authorizes the president to investigate, block, during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit importation or exportation. Absent from this lengthy list of powers is any mention of tariffs or duties. That omission is notable in light of the significant but specific powers Congress did go to the trouble of naming. It stands to reason that had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly. And it consistently has in other tariffs statutes. Regulate, as a term is ordinarily used, means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or law. The facial breadth of regulate places in stark relief what the term is not usually thought to include: taxation. Government cannot identify any statute in which the power to regulate includes the power to tax. We are therefore skeptical that in IEEPA and IEEPA alone, Congress hid a delegation of its birthright power to tax within the routine power to regulate. Taxes, to be sure, may accomplish regulatory ends, but it does not follow that the power to regulate something includes the power to tax as a means of regulation. When Congress addresses both the power to regulate and the power to tax, it does so separately and expressly. That is unsurprising, as the power to regulate commerce is entirely distinct from the right to levy taxes. That Congress did not grant those authorities separately here is strong evidence that regulate in IEEPA does not include taxation. The neighboring words with which regulate is associated also suggest that Congress did not intend to regulate to include the revenue-raising power. None of IEEPA's authorities include the distinct and extraordinary power to raise revenue, and the fact that no president has ever found such a power in IEEPA is strong evidence that it does not exist. Our task today is to decide only whether the power to regulate importation is granted to the president in IEEPA embraces the power to impose tariffs. It does not. The question is not, as the government would have it, whether tariffs can ever be a means of regulating commerce. It is instead whether Congress, when conferring the power to regulate importation, gave the president the power to impose tariffs at his sole discretion. And Congress's pattern of usage is most relevant to answering that question. That pattern is plain. When Congress grants the power to impose tariffs, it does so clearly and with careful constraints. And it did neither here. Insofar as the government relies on our wartime cases themselves, they are facially incongruous. Regardless of what they might mean for the president's inherent wartime authority, all agree that the president has no inherent peacetime authority to impose tariffs. The president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope. In light of the breadth, history, and constitutional context of that asserted authority, he must identify clear congressional authorization to exercise it. IEEPA's grant of authority to regulate importation falls short. IEEPA contains no reference to tariffs or duties. The government points to no statute in which Congress used the word regulate to authorize taxation. And until now, no president has read IEEPA to confer such power. We claim no special competence in matters of economics or foreign affairs. We claim only, and we must, the limited role assigned to us by Article 3 of the Constitution, which is to say what the law is. That's under Marbury versus Madison, a very old case that establishes what the role of the judiciary is. Fulfilling that role, we hold that IEEPA does not authorize the president to impose tariffs. And that is the summary of the majority opinion. I have included the whole opinion, the ruling, the link in the references section in the description box. If you want to read the 170 pages, I'm probably going to read the concurrences and dissent at some point, but I really quickly wanted to come out and tell you that this was the ruling of the Supreme Court, and the Supreme Court has stood up against Donald Trump. That shows that the power of checks and balances still works to this day, so far. And this is not to say that Donald Trump will not impose tariffs based on other authorities. He has already ordered 10% tariffs globally based on some other authority. And that's what Donald Trump is going to do. He's going to pick statutes that are going to have tariffing authority, and he's going to test how far he can take them. Because this particular law, IEEPA, does not give him that power. He wanted to assert the emergency power that IEEPA gives, which is broad in its authority, but IEEPA doesn't give him taxing power. And he wanted to squeeze in taxing power into IEEPA, and the Supreme Court said, no, sorry, you can't do that. This is a case of statutory interpretation, and that is why it is important to note that this doesn't necessarily mean that the court is going to side with the people or with the correct issues that we come up with when we bring up the cases that have to do with violations of constitutional rights on individuals. That is far more interpretive, and the Supreme Court has far wider discretion to sort of rule on the interpretation of constitutional rights and their limits. With statutory interpretation, however, their power is limited to interpreting what the statute says based on all other law that came out of the Supreme Court, as well as other statutes that compel the specific delegation of tariffs to the president for it to operate. So with that said, thank you so much for listening, and I will talk to you soon.